Good morning and welcome to the Investment Migration Report. Today we have as our special guest Aaron Grau, who is the Executive Director of IIUSA, the EB-5 Industries nonprofit trade organization. This morning actually couldn't be any more timely for our program on our podcast, as Aaron could weigh in on the federal lawsuit that just came in and was ruled yesterday in the California federal court. So with that, Aaron, welcome. And maybe we just jump right into it. Maybe Aaron, tell us about the lawsuit.
You don't waste any time. Well, I mean, we could start at the very beginning, or we could start at the very end and sort of backfill. I'm not sure how you'd like to proceed. And the ruling came out late yesterday afternoon, Pacific time, maybe around 6 o'clock or so. That the Bering Regional Center, which was the plaintiff in a case against the Department of Homeland Security, won its case, and the federal district court vacated the regulations that most recently changed the administration of the EB-5 Regional Center program. Most importantly, within those regulations were methods by which targeted employment areas were defined or are defined, and of course the investment amounts. The regulations raised the investment amounts from $500,000 in a targeted investment area to $900,000. Now that the regulations have been vacated, the investment amounts will drop back to $500,000 unless there is a stay that the defendant, the federal government, applies for a stay with the federal district court and it's granted, or the federal government otherwise appeals the decision, or they do neither and they simply follow the court's order, which was to take action on the regulations, presumably as it sees fit, and obviously within the parameters of the law, specifically the Administrative Procedures Act. So the order specifically remanded the matter back to the Department of Homeland Security for it to do what it needs to do. And that's the big question right now. That's the big question. Notwithstanding the possible stay in the Ninth Circuit at the district court level, the question is, now that the Department of Homeland Security has it back, what's their next step? I've spoken with folks at DHS during the litigation, and of course they were not able to comment much at all on the litigation, and I would have not expected them to. But what they did tell me was, they said, Aaron, look, we support the program and we support the regulations. Take that for what it is. At the time, I took it as meaning that they would take every step possible to keep the regulations as they were promulgated and finalized back in November of 2019. I still feel that way, but as we spoke earlier, Abteen, my opinion, in $5 will get you a cup of coffee. So, we could jump into the weeds, I suppose, on the arguments that were in the case, and why the court ruled the way it did. I mean, I mentioned to some of our board members earlier this morning, I said, the order says exactly what I thought it would say, assuming the court would rule in this way. I mean, her logic was, I understand her logic. I mean, it made sense. To what ends the ruling impacts everything is undetermined, because like I said, we just don't know what DHS is going to do now.
So Aaron, by the way, I don't think $5 these days gets you a cup of coffee, probably at least $7. But I wanted to ask you, I mean, I think, I've gotten hundreds of emails from last night and this morning, and hundreds of messages on, WeChat, WhatsApp, every medium you could think of from our investors, agents, lawyers, everyone asking, what does this mean? Is investment amount 500,000 today? Can we go and accept $500,000 investments today? What happens to those investors that invested at 900,000? Lots of questions, lots of stuff. But maybe I think we'll kind of in an organized fashion jump into those, one at a time. I think it's important to mention what I think a lot of our listeners and a lot of stakeholders in EB5 may not understand is, the different parts of the government and what authority they have. Obviously, the Department of Homeland Security is an agency under the executive branch, and U.S. Citizenship and Immigration Services is under the Department of Homeland Security. So that's all the executive branch. Then you have Congress, you have Senate, and you have the House. What does this mean? I mean, does this invalidation of the rule reauthorizes the program, or is there still a reauthorization that is needed for the program to survive? Maybe if you could just weigh in on that.
I don't think that the ruling will impact the legislative process. As you pointed out, I mean, in the United States, those are two very distinct branches, the judiciary and the legislative. And we have a very real, frankly, some have described it as an existential date in front of us of June 30th. That is the date that the Regional Center program expires. If that were to happen, there are other unknowns that I think are driving a lot of anxiety as well. Whether those unknowns, we just don't know. We just don't know what they are. So, I mean, we're working very hard to avoid trying to figure that out. We want to make sure that the program is reauthorized by the 30th. So, the legislative process that's underway right now is intended to avoid that expiration. Interestingly, it's worth noting, today is the 23rd, I should know that. The Senate adjourns tomorrow around noon, maybe 1 o'clock or so, depending on their business, on the 24th. If the Senate doesn't act in order to reauthorize the program by tomorrow, we're in trouble. I have to be honest with you, because we have the Senate that has to we have the Senate that has to pass the bill, and then we have the House of Representatives that has to pass the bill. If the Senate both have to do it, both bills have to be exactly the same, and then the president signs it into law, and we're okay. However, the Senate only has until tomorrow midday to pass the bill and then push it over to the House side. If the Senate doesn't act in time, it will adjourn and it will not reconvene until well after June 30th. So there won't be a reauthorization. So today's a pretty timely and pretty topical day for us to be talking. But going back to maybe a part of your original question, the legislative branch and the judicial branch, they rarely cross paths, and I personally don't see the ruling today or the ruling yesterday in the Barron case having much of an impact on the process that's already underway in this House and the Senate. There was a time when I thought a ruling from the Barron case would have impacted that process, but that time long since passed. The bills were drafted, they've been introduced, and now they're already being considered through what's called a hotline process. So it'll add some confusion, it'll add some anxiety. I don't think technically it actually impacts the process though.
So Aaron, for our listeners that may not be familiar with the legal procedures in the United States, do the executive branch or the judicial branch have the power to re-extend the program or reauthorize it?
No. Only the legislature can do that. Congress,
Senate, and the House, and they have to basically approve it in a unanimous bill that's identical, right?
Right. The House can't pass a bill that's different from the Senate. They have to be exactly the same. And then the president has to sign it into law.
Sorry, I've been monopolizing the entire time. My amazing co-host, she has some questions for you. So Priya,
you did mention the hotline process, and I wanted to know if you could just elaborate on that a little bit more for our listeners who might not be familiar with how that works.
Sure. So in the US Senate, there are essentially two ways to pass a bill. You can either put the bill through what is called regular order, in which case typically there is an agreement on debate on the Senate floor. Amendments are offered on the Senate floor. This is all after things have gone through committee, of course. And then ultimately there's a vote on the Senate floor to pass or to not pass a piece of legislation. That takes time. In fact, it takes a lot of time. Sometimes the other way to go about passing a piece of legislation is simply by asking for unanimous consent. In other words, let's skip all of the argument and debate. A senator can go to the floor and say, I ask unanimous consent to pass this bill. And if there are no objections to that request, the bill passes. It's usually, the process is usually reserved for non-controversial bills, or perhaps in this case, when there's simply no time left to address it through regular order. The hotline process was created by the Senate in order to expedite the unanimous consent process. So, and all it is really is, it's the Senate offices who are sponsoring the bill, they fill out an electronic form explaining what the bill is. It's emailed out to each Senate office, and with a an alert essentially saying, hey guys, we're going to ask for unanimous consent on this bill. Does anybody have an objection? And that notice is in place roughly 24 hours or so. It's a way to sort of vet out exactly who may be objecting to the bill or who has questions about the bill. And it allows the sponsors of the bill to address those questions and those objections. Because remember, ultimately, the Senate is asking for unanimous consent. So it only takes one senator to stop that process. So the hotline is really just a preemptive way to figure out who might have questions or opposition to the bill.
And can we maybe get into, there have been various bills being passed through, and do you have any insight into what some of those were or are, and sort of what the outcome might be?
So clarify, which bills do you mean?
Well, I've heard several things from different people. I've even heard that there's a drafted bill that the price might come down to 700,000.
Oh,
I've heard various things. So maybe do you have some insight into what those are, and if they hold any kind of foundation with what's going on right now?
sure, I understand. Sorry. Those drafts have no impact on the conversation. The bill that has been hotlined, the Grassley-Leahy bill that we're talking about, does not address investment amounts whatsoever. The only things that bill addresses are what have been referred to as integrity measures, which we can talk about if you guys like, and a reauthorization timeline for the program. In this case, it would be for 2.5 years. So any other bills that have been discussed or floated, or any other legislative language that's been suggested that would address investment amounts, like to 700,000, for example, those are not on the table, and the legislative branch is not considering them.
Aaron, I really want to jump in and go over the history of the various different legislations and how we got to this point, because I think our audience really is hungry and wants to really find out how we got to this point. But before we jump to that, I really want to ask you, just to really explain to the audience what this ruling, this federal ruling means. If the EB-5 program expires tomorrow, essentially, or at the end of the month, 30th. Whether the program expires of 500,000 program or $900,000 program, it shouldn't make a difference. It's still expired until the only group that has the power to reauthorize a program is Congress. Unless Congress reauthorizes, the program is dead. So I want to have you talk to the audience about that. But also, today mechanically, a lot of investors and agents, in Vietnam and India have called me, and they believe as of today they can go and accept investors legally under the $500,000 level. But can you talk about that? Can you talk about what the remand process means? and what the agency would have to do for that 500,000 to take effect essentially today or tomorrow before the 30th expiration?
I can talk about it. I need to be really careful because I actually don't know the answers to your questions. And I think that's part of a lot of the anxiety that people are feeling. I don't think anybody really knows the answer right now. I think if I was to opine, I would say, technically speaking, the regulations that are in place now, following the court's ruling, place the investment amounts at 500,000. Mechanically, however, that begs a lot of questions. For example, I know that regional centers have offering documents that don't reflect that amount. I mean, it will take time. I'm assuming, I don't run a regional center, but I'm assuming that regional centers would need time to adjust to that new investment amount in order to legally make an appropriate offer at $500,000. So just because the regulations say it's $500,000, I don't know how quickly the industry shifts to actually using that number. That the answer to that question is definitely above my pay grade. As far as the remand is concerned, again, that's another sort of unknown. The court remanded the matter, it said, back to the Department of Homeland Security. In other words, it basically said the regulations that you guys finalized in 2019 are no longer valid. Go figure it out. The remand, now that it's been remanded back to the Department of Homeland Security, I mean, the question is, what exactly will they do? I am firmly convinced, and I may be proven wrong, but I'm firmly convinced that the administration, meaning the Secretary of Homeland Security, Mayorkas, as well as the President of the United States, are committed to the $900,000 level. In other words, they're committed to the previously promulgated regulations. Just because the regulations were finalized, in other words, signed off by the wrong person, which is what the court said, which is why they're invalidated, I don't see that as a long-term stop to what the administration feels is the right policy. They will find a way to reinstitute appropriately the $900,000 level. I just don't know how, and I don't know how long that will take. Add to that, I don't know how long it takes for regional centers to adjust to the $500,000 level, nor do I know how those two timelines intersect. I would feel pretty bad for a regional center that goes through all the trouble of, reissuing its offering statements at a $500,000 level. Maybe that takes 2 months to figure out how to do correctly, only to have the Department of Homeland Security find a way to reinstate the regulations back to $900,000. And that means the regional center's got to go back to all the investors it's been talking to and readjust everything again back up to the higher level. There's just a lot of unknowns. And so in some instances, I think investors are going to jump at the chance. I think, I know that people are already promoting this $500,000 amount around the world. So I think some investors are going to jump at that. I would just urge caution. I think other investors are probably going to wait and see how things shake out. But I don't know. I honestly, I wish I had an answer, but what I can tell you for sure is that the Department of Homeland Security will address this. I believe they will put it back at $900,000. I don't believe that this process of the court's decision and the administration's actions on the $900,000 decision impacts the legislative process whatsoever. They are all separate things. And we're just going to have to wait and see how things filter out. To say otherwise would be misleading, I think.
So Aaron, we're regional centers and we operate regional centers and developers, and Priya is on the fundraising side. So, we're very interested in 500,000. If we can get, the investment back to 500,000, there'll be a huge amount of more investors than we have currently at the 900,000 level. But to Priya's point, I think there have been several different iterations of bills that have been introduced either by the House or by the Senate. And when the EB-5 program initially passed in the 1990, Ted Kennedy, who was kind of the champion of EB-5 initially, we were kind of copying the Canadian program back then. They always intended for the program to be $1 million program, and with a caveat that if you invested in a certain area, target employment area, that you could invest in 500,000. They never imagined that it would just be an only $500,000 program for the next 30 years. They assumed it was $1 million program back then, and imagine inflation that's happened since 1990 till today. So the reality was they always intended for this to be $1 million program, and they thought maybe a small subset of investors would come in these targeted employment areas of 500,000. And then also in a lot of discussions with the Senate and the House, they have expressed that even 900,000 they thought it was too low, that the program would always be $1 million program. Maybe you can weigh in on that, and then also talk about what it would mean if the program expires on June 30th, but essentially, June 24th tomorrow, because that's the last day Senate's in session. If you don't mind maybe jumping into that. That's a very loaded question, but if you could weigh in on that.
I'm not even sure where to begin there, Abteen. That was a long question. I think that if the program expires, the Department of Homeland Security will need to, in all likelihood, reissue guidance with regards to how it will handle I-526 applications, and frankly, any other applications and forms that pertain to the EB-5 program, the 924s for the regional centers, the 924As, all of it. In the past, when the program has lapsed, the guidance, at least from 2018, the guidance has simply said that the Department of Homeland Security will hold applications in abeyance for a reasonable amount of time, right? In all likelihood, believing that since these previous lapses were tied to the appropriations process, because that's where our authorization has always been, on spending bills that absolutely must pass in order for the government to receive money to do its thing, that a reasonable amount of time, nobody really cared about what it was. I mean, a reasonable amount of time was whatever amount of time it took for Congress to get its act together and pass the spending bill so that the Department of Homeland Security had its money to defend the homeland. So there was never really any question that the Department of Homeland Security's spending bill would never pass. It would, and therefore so would our authorization. I would consider that a lapse. And the words that we use here, I know, have meaning, and so I use them with caution. If the program is not reauthorized this time, I would categorize it not as a lapse, but as an expiration. That doesn't mean that the program can't be brought back. In fact, I'm sure that all of us would work our tails off to make sure that it is. But I do think it's important for us to understand the difference between what has happened in the past as a lapse and what will happen now, because now we're no longer tied to that must pass authorization bill. Now it's something that we're out on an island, so to speak. So I believe the appropriate word to use is expire. So back to your original question, what happens after that? Again, we don't really know. As I said, precedent from the Department of Homeland Security is to hold applications in abeyance until things get figured out for a reasonable amount of time. The next step after the expiration or lapse, or however you want to qualify it, is unknown. So we don't know what a reasonable amount of time is. And we don't know what the Department of Homeland Security can do. We don't know to what extent they will be able to devote resources to a program that no longer has an authorization. All of that will light a fire under the industry, to be sure, to find a way to reinstitute the program. But we don't know what that process will look like. We don't know how the political landscape will shift. So again, it just comes back to a lot of unknowns. I have every confidence. I am cautiously optimistic that we're going to be just fine. Honestly, I think that everybody in the Senate understands the value of this program. I think they understand what it means to the United States. I think they understand what it means to immigrant investors who are putting a hell of a lot on the line. I think everybody has a clear understanding about that. I think that what we're seeing in Congress right now, some people would call it maybe politics as usual. I'm pulling my hair out, but I think everybody understands what's at stake, and I'm optimistic that at the end of the day, we'll be okay. We're going to be just fine, and hopefully we won't have to discuss at any more length the nature of the question that you asked as to what happens next.
Has there been any discussion? Because I know one of the questions I get on a daily basis from investors who have already invested, last year, the year before, they're worried about, obviously, what's going to happen to their applications. So I know you mentioned that they're going to hold the applications for a while, but has there been any discussion in terms of grandfathering in for applications that were filed before in case there is some kind of expiry on the program?
Not to my knowledge. I know that there was a suggestion that grandfathering be included in legislation that would reauthorize the program. That request was denied. I mean, it was not included in the legislation, but I was always sort of confused as to how that language would work in any event. If the bill to reauthorize the program has language in it that grandfathers applicants and the bill doesn't pass,
right,
then neither does the language that would grandfather the applicants.
Yeah.
So it was a little confusing to me. The suggestion was raised, and then it hasn't been picked up since. And I know that it's not actually in the text that's being hotlined right now.
So Aaron, I think we've been trying to get a new EB-5 legislation reauthorized for the past 7 years. I think you've been helping us from IIUSA standpoint the last 3 or 4 years. And we're at the 25th hour of a bill potentially happening, which we have 3 sponsors in the Senate side and 17 sponsors on the House side. First time ever in the last 7 years, or really in the last 30 years, that we've had reauthorization of EB-5, where we have had identical bills in the House and the Senate. I think I've been hearing a lot of misinformation that this is somehow a Republican bill, and it's, Republicans don't like immigration, so they're trying to kill immigration. But the bill is bipartisan. In fact, 2 of the co-sponsors on the Senate side are Democrats. In fact, Senator Coons and Senator Leahy. Senator Coons was the replacement of President Biden, very close friend of President Biden's. On the House side, we have, it's split down the middle on the 17 co-sponsors. In fact, we have one more Democratic sponsor, I think, than the Republican sponsor. Maybe if you could just touch on that. And then my next question, the follow-up is, I don't think our audience understands the amount of work that you and other stakeholders spend on a daily basis to get us to a point where we are. Maybe just talk about that a little bit, because I think for our listeners, I think they'll be interested to know, on a daily basis, what do you guys do and how you're in the trenches every day fighting the fight to get this program reauthorized.
The bill is bipartisan, to your point. It's also bicameral. There has not been a reauthorization effort that has included a bicameral effort. In other words, the same bill introduced on the House side as it has been on the Senate side. Senator Coons and Senator Leahy, Democrats, Senator Grassley, Republican. To me, that is bipartisanship. And to your point on the House side, I actually think it was I think we now have 10 Democrats and 15 Republicans on the House side. I'd have to go back and check, but clearly bipartisan. And interestingly as well, there's a wide spread in the spectrum, the political spectrum among our co-sponsors. One of our co-sponsors is a congresswoman from California. Her name is Katie Porter. She represents the 45th District of California, I believe, and she's seen as, generally speaking, a very progressive member of Congress. We also have a gentleman named Guy Reschenthaler from Pennsylvania, a Republican who is seen as a very conservative member of Congress. He comes from a very red, pro-Trump district. So it's not just bicameral and bipartisan. It's like really bipartisan. I mean, to have someone like Katie Porter on the same bill as someone like Guy Reschenthaler, I think says a lot about the program itself. I think it speaks to members' recognition of what the program does for their communities and what it does for the United States. And you're right. As far as I understand, I've been with the association, like you said, about 3.5 years now. I certainly have never known legislation to have reached this point, and I don't think it ever has during the program's history. Typically, the reauthorization effort for this has always been sort of behind closed doors. It's been, tucked away, as we talked about, on these appropriations bills, and it's been sort of pro forma and very difficult to get change and so forth. That's just not the case this time. This time it's very much out in the open and very much bipartisan. And to your other question, I mean, it has taken a lot of work. Folks like yourself and other members of the IIUSA board, our lobbyists, as well as our lobbyists from other companies, all working together on a daily basis for many hours each day to adjust the nuance of messaging on a daily basis. And then the other part of it is just plain education. I think many people, I don't know if they would be surprised or not, but I mean, many members of Congress don't know what EB-5 is. I mean, they may have hundreds of millions of dollars worth of investment in their district, and because it's such a small and somewhat segregated program within the construct of immigration itself, really it's an economic development program, not an immigration program. So it's such a small program in the broader construct that members don't really even understand what it is. There's always an assumption that if they do know what it is, there's an assumption that it's primarily for Chinese immigrant investors. There's an assumption that it must be bad. We always hear about fraud. A lot of stereotypes and misinformation about the program is out there. So we have spent an inordinate amount of time educating every member of Congress that we can speak to about what the program actually is, what it actually does, what it actually means to them and their districts and their constituents, so that they understand that when the time comes to vote to reauthorize the program, they're not reauthorizing a program that's somehow bad for them, or they're not furthering some sort of de facto fraudulent program. It's exactly the opposite. I mean, it is a job creating juggernaut that is leveraging dollars that are non-tax dollars. So a lot of our work has been just education, a lot of shoe leather in explaining to people what the program is and why it's worth paying attention to. And we've been successful. I mean, the fact that we have 25 co-sponsors in the House and our meetings continue today says a lot about the progress that we've made. And, knock on wood, if we're able to reauthorize this program, we now have, no fewer than 25, 6, 20, close to 30 members of Congress on record supporting this program. And, we would surely go back to them to help improve the program further, more visas and whatever else the program needs to strengthen. So it's a lot of work, but it's work worth doing.
You've done a great job. And, Priya and I, this is close to us because, we're both immigrants. Our families immigrated from Iran and India, to the United States and Canada. So this is not only important because it's our business, but it's also important because there's, for every one of these visas, there's actually a real family that's affected by this. And if the program were to die tomorrow or on the 30th, people overnight will lose their immigration benefits. And that's disaster. And I think a lot of the stakeholders just don't really understand that. And I think, they just assume that, Congress is going to kick it down the road, but we know that that's not true. Maybe you want to weigh on that, and I'll yield back to Priya. Sorry, I've been monopolizing most of the questions.
All good.
The interesting dynamic that Senator Grassley and Senator Leahy have set up is that there is no kicking the can down the road. A problem in the EB-5 community, and I don't think we can stick our head in the sand about it, has been fraud. I mean, investors make investments knowing that they're doing so at a risk. That's the nature of an investment. But they certainly seem to be at more of a risk than, say, I would in making an investment, because many of the investors don't speak English. They may not have a comprehensive understanding of real estate transactions in the United States. And there are people who take advantage of those situations. And it's happened more than once. What Senator Grassley and Senator Leahy feel passionately about is the need to put a stop to those sorts of situations. And so rather than set up a situation in which the can is simply kicked down the road and the status quo is allowed to continue and continue and continue, they've basically laid down a very hard marker. They've drawn a line in the sand, and they've said, this can no longer continue. We can no longer allow immigrant investors who are putting as much as they are on the line to be defrauded. And therefore, the integrity measures that we are insisting on must be part of the program, or the program will not be kicked down the road. I mean, it's a really, in some ways it's patronizing, but in other ways, it's something that the community and the industry absolutely needs. And so the legislative lines that have been drawn, for better or worse at this point, disallow that kick the can down the road. Senator Grassley has been quoted in several newspapers at this point saying that he would not agree to a simple, clean extension, is what they're calling it. He simply won't allow that to happen. He insists that these integrity measures and protections for investors are part of the legislation. It's a good thing, but it does entail a bit of brinksmanship, which brings me back to my cautiously optimistic comment from earlier. We have today and we will have tomorrow morning to be sure that the Senate acts and to assure these integrity measures and investor protections. And then we jump over to the House side to finish the process over there.
Can you talk to us a little bit more, just elaborate a little bit more on what these proposed integrity measures are, what they're proposing to put in place that would protect investors?
Sure. I don't have the bill in front of me, but just off the top of my head, I know that if an investor, for example, finds himself or herself part of a project that itself has been deemed fraudulent, that the developers, for example, for lack of a better phrase, have been caught with their hand in the cookie jar, misappropriating dollars, for example. The Department of Homeland Security at that point has the ability to come in and stop the project, stop the program. They have the ability to essentially kick a regional center out of the program. In those instances, what happens to the investors' dollars who, through no fault of their own, have been caught up in this mess that's been created by someone here in the United States that is part of this development team? Well, what this bill would do would allow an investor in that position to withdraw their dollars, to get their money back, and reinvest it into a different project in the United States. And most importantly, it would not force that investor to lose their place in the immigration application process. They would not lose their place in line. Because it's just not right for someone who, through no fault of their own, is swept up in someone else's wrongdoing. Other integrity measures sort of fall on the side of the regional centers with some increased oversight. So this was a big debate between IIUSA and the drafters of the bill. Of course, we were not that interested in having, regional centers' business models be completely turned upside down. There are costs to that, and there's a cost-benefit analysis that needed to be placed, because regional centers are, the functionary of the economic development that this whole program is intended to allow. So if you have too much oversight, it sort of bogs down the process, and they're not able to actually facilitate the economic development. So we didn't want too much oversight, but we did recognize we needed some oversight in order to clean up what I'm just describing. So we came to a very good balance. I think that the integrity measures, as they apply to regional centers, now include things like increased transparency. So for example, someone like you oversees a broker dealer, someone who is working with investors, would have to disclose fees that you would earn, and they would have to be disclosed to the investors, so that the investors know how much of the money they're investing is actually going to fees as opposed to the project itself. I mean, that is a determining factor in how a person makes an investment. So those are a couple of examples, and hopefully they sort of illustrate the general nature of what the integrity measures are intended to do. They are intended to clean up the program, make sure that the bad apples don't have an opportunity to continue doing business, and to provide assurances to investors, and to protect good faith investors. And I think those are valuable, very valuable. It's a sign that the program's sort of growing up a little bit, which is good.
Right. I mean, some of the things I think that are in the bill, for example, that you have to have construction monitoring. What does that mean? I mean, the old days, you hear that, a regional center raised a couple $100 million, and the regional center founders were buying yachts and private jets with it. So having construction draws means that, as you, spend $10 million on concrete, you get those receipts, you send it to the bank, you send it to the regional center, and then you do a draw. They release that money that you've already spent. So you don't have the option, or you don't have the opportunity, or, the ability even to be able to steal that money and go do things that are non-construction or not part of the program, not part of the project. And those things are, I think, really important. I think some of us, we already do this as best practices, but to have, Congress legislate that, I think it's important. Other things, having a fund administrator, not having traditional escrow accounts, or in some cases, regional centers don't even have escrow. They just take the money and put it in the project. Those are, again, integrity measures that I think are part of the program. And I think a lot of people do agree with those integrity measures, but there's definitely a split. And I think I want to jump into the beginnings of how these differences of opinions started. I mean, for our audience, I think it's important to understand, how do you get a senator who is a Republican from Iowa, Senator Grassley, and a Democrat from Vermont, Senator Leahy, on the same side of the on a bill, and then you have Senator Schumer and Senator Cornyn, Republican and Democrat, on the other side? And is this been traditionally a Republican versus Democrat debate, or has there been another reason? Maybe you can elaborate on that.
Well, first of all, let me say this, that I will address that, but I mean, back to the integrity measures. and I don't intend this as anything shameless here, but it's worth noting that the integrity measures are intended to address organizations that are not like Brevet. They're best practices are something that organizations need to have, and some do it a hell of a lot better than others. So it's really the folks who are a bit more fly by night, I think, that Senator Grassley and Leahy are intending to target, or those who might be so big that they feel that they can do whatever the heck they want. With regards to Grassley and Leahy, it is an interesting debate. I don't think it's Democrat and Republican at all. We talked about how the bill is bipartisan, and that's important, especially in this climate in the United States with regards to immigration. Unfortunately, in my opinion, the climate is still pretty toxic with regards to immigration. And so it's important for us to be able to demonstrate that insofar as this is an immigration program, I don't believe it is. I believe it's an economic development program, but it is an EB-5 visa program that we want to demonstrate bipartisanship, and we certainly have. But the program itself is more of a debate between urban programs and rural programs, which is why you have folks like Grassley and Leahy from rural states, sometimes on the other side of the table from gentlemen like Senator Cornyn and Senator Schumer, again, Democrat and Republican, who have rural communities in their states for sure, but are very frequently paying close attention to the urban interests of real estate development. There is nothing wrong with that. It's healthy, it's good. We need to have those sort of debates and balanced approaches. But it is interesting to point out that this particular program is not about Democrat and Republican. It's about making sure that the investments that immigrant investors are willing to make are provided to the most effective areas, or the areas that can be impacted the most in the United States. Not just urban, even though that's a very attractive place for immigrants investors to place their money, but also to rural, which is where the United States needs to have more of an investment, arguably. So it's a very interesting dynamic from a public policy perspective. If you're talking about non-tax investments as a governing authority, where do you want those investments to be? Where are they going to do the most good? And you need to balance that with where the investors want to put it. So it's been a very interesting and healthy and good debate. I will give a plug to a colleague of ours. You may know her, Alex Lovelace, who is chairperson of the Rural Alliance. IIUSA has worked very closely with the Rural Alliance and making sure that we're able to represent their interests, or help them represent their interests. But we're also very closely tied to organizations like Brevet and other companies that are focused in urban communities. I see the background behind you in New York there. So
Hudson Yards
conversation. What's that?
That's Hudson Yards behind us, actually.
Is it really?
Yeah.
Okay.
Or on this side.
So it's an interesting debate.
That is interesting. I've actually not thought of it being a rural versus urban type of debate at all. So that's really interesting.
Yeah, I mean, when I came to the program, it was made clear, and I understand why, that investors are much more willing and interested to put their money into something that they recognize. In New York, Hudson Yards, other projects in New York, or Miami, or Dallas, or Los Angeles, or San Francisco, or Seattle. I mean, these are places that immigrant investors recognize and believe correctly that can provide a return on their investment. They don't really think of Burlington, Vermont, or Ames, Iowa, or North Dakota, or any places like that, because even we in the United States sometimes consider these places flyover country, right? But the truth of the matter is that from a public policy perspective, investment in these communities is very necessary. And furthermore, they can be very profitable for investors. I mean, when you consider the development of, for example, ethanol plants in the Midwest, processing plants that takes corn and corn byproducts and turns them into ethanol, that can be a very profitable endeavor. Steel mills, for example, in places like Arkansas, can be very profitable. But I mean, no one in, I don't know, Mumbai, for example, that's not their knee-jerk reaction to say, oh, yes, my investment for an EB-5 program, I'm willing, I can't wait to see it go to work in Arkansas or North Dakota. It's just not something that people typically think of. But the purpose of the program in the United States is economic development. And so policymakers wisely ask themselves the question, where should we encourage this economic development? And so you get a bit of a back and forth between urban community priorities and rural priorities. And again, I think that conversation is healthy, and it's something that we will continue to have.
I think in the past, Senator Schumer has introduced a bill before. I think Senator Graham has introduced a bill. Congressman Amodei out of Nevada has introduced a bill. We're agnostic. We don't really care, if it's a bill that's introduced by Senator Grassley or Leahy, if it's a bill introduced by Senator Schumer or Corner on the other side. The reality of it is that, we're 6 days away from the program lapsing and sunsetting and putting many immigrant families' lives in jeopardy because, they're in limbo. They're not sure if they can continue their immigration. They're not sure they're going to be able to get a green card. They've done what they were supposed to do. That, Congress told them if you invest 500,000 and later 900,000, then you qualify, and then there's that could all be in jeopardy. And the reality is that there aren't any bills right now by Senator Schumer or Senator Corner or Congressman Amodei today that we could vote on, or that members of Congress could vote on, that could re-extend the program. The only game in town today is a bipartisan bill by Senator Leahy and Senator Grassley and Coons, and 25 co-sponsors on the House side. And that's the only option. It's that option or the program expiring. And I think that's a reality a lot of investors and a lot of our colleagues in the business don't understand. They just think that, it's been reauthorized and kicked down the red road 21 times. It'll just happen again. I don't understand that the method of that happening is it would have to be part of continuing resolution, which is not. And Senator Leahy has the power to put it back or not put it on the continuing resolution, which him and Senator Grassley, as you expressed earlier, have said they will not put it as part of continuing resolution. So best case scenario, the program lapses, and maybe in October they can do something and add it. So what happens to investors between now and October? Maybe you can tell our audience a little bit about that and what that would mean in terms of lawsuits and in terms of not happy investors and also people losing faith in the program. Maybe elaborate on that.
So you're right. The GrassleyLeahy Bill, and in the House, the bill has been introduced by Representative Stanton from Phoenix and his Republican colleague, Representative Fitzpatrick from just outside of Philadelphia. Those bills, they're identical, so you could call it the bill. Is the only game in town, and for quite some time, there has been and there continues to be opposition to that bill, and the reasons for the opposition include issues with some of the integrity measures. Some people feel that they are overreaching. I disagree. There are concerns with the bill because it doesn't include language pertaining to investment amounts. That's a very sticky, contentious issue. And in years past, addressing that issue and other issues like the definition of TEA have always mired the reauthorization process down. It's always ended poorly for the EB-5 community. So there are those, however, who still feel that those issues should have been included in the GrassleyLeahy bill, and so they oppose it. So to your point, however, traditionally, if there is enough opposition to a bill, or if there's reason enough to persuade someone else to introduce an opposing bill with different ideas, then typically champions of that position would be successful in convincing Senator Smith from wherever to introduce a competing piece of legislation. However, that never happened. It never manifested, not on the House side and not on the Senate side, despite the reasons to oppose the Grassley-Leahy bill. No other member of Congress, House or Senate, saw fit to introduce a separate EB-5 reauthorization bill. It just, no one ever did it. That begs questions as to the arguments for opposing this bill, but we won't get into that. It goes to your point, Abteen, where we're now left with one option. There's one game in town. It's S-831 on the Senate side, HR 2901 on the House side. And if you want this program to continue, that's it. You have to vote for this bill. You have to pass this reauthorization package. What happens to investors if the bill doesn't pass and the program expires or lapses, or like we said before, pick your word? That's another unknown. I think quite certainly you will have investors immediately scratching their heads and wondering if they have lost their place in line for their immigration status, their visa. What that concern prompts them to do, I can't say for certain. I think you can assume that some immigrant investors will ask for their money back. If that happens, I don't know to what extent regional centers or developers are in a position to do that. To your point, it could cause a lot of confusion and stress that IIUSA would immediately begin addressing in an effort to somehow bring the program back. But it's another unknown that we hope to avoid. And this opportunity, this podcast, very timely in an effort to get the message out and help people understand what we're doing to make that happen. But just a lot of unknowns at this point. It's also, I think it's worth noting as well, some people have accused Senator Grassley, who has been painted by many as sort of an ogre, the specter of the community who wants to kill the program. And I can certainly see why people would think that. I mean, Senator Grassley has some very ardent views. He doesn't necessarily think highly of the program, which is why he's so insistent on these integrity reforms. But I think it's a gross mischaracterization to say that he is in any way acting in bad faith, that he in any way wants to proactively kill the program. He and his colleague, Senator Leahy, back to your point, Abteen, are the only ones who have kept their shoulder to the grindstone. They're the only ones who have put in the long hours of debate and drafting. They're the only ones who have suffered the slings and arrows of opposition to try to improve the program, strengthen the program, reauthorize the program. There's no one else out there doing the work. They're doing the work. They deserve kudos for it. And we all should recognize their priorities in the effort. And their priorities are the protection of good faith investors and oversight to make the program more transparent. Who's against that? Why would you be against that?
I totally agree. So I've been involved in EB5 since late 2011, early 2012, and I think PRIA has been just as long. It used to be, the pilot program that was enacted in 1993. Every 3 years it expired, and it would go, in front of the House. And I remember in 2012, I remember it was like, I don't know, in the House was like 433 to 3 was the votes. There were 3 people that voted against it, and in the Senate it was 97 to 3, and it was basically a rubber stamp. Every 3 years we get reauthorized. And And I think one of the realities of the program was in the early days, in the early 1990s, it wasn't very popular. People didn't really know it. Not a lot of real estate developers or other project, developers were using it to finance projects. But it slowly started kind of increasing in popularity. But it's important to know. I think one of the early adopters of this program were real estate developers, smaller real estate developers in California. So for many, 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 many years, the majority of the money in the program went to the state of California, and many other states hadn't really figured it out. A lot of real estate developers hadn't figured it out. It wasn't, prevalent, and real estate developers had all kinds of other options for financing their projects. And then, in the downturn of 2007, as developers were looking for alternative sources of capital, it started really becoming popular in states like Texas, Florida, and New York, and other states started using it. And then it became where, as you mentioned, a lot of immigrant communities, and a lot of immigrant investors want to go to places with large immigrant communities like New York and LA that have large immigrant communities. And I think since like 2013 and 14, it became where more than 65% of the money was going to one state, New York, and 65%. And this time around, I think members of the House and Senate started paying attention, and more notably, one developer in particular that was developing Hudson Yards, something like $3 billion went to that one particular developer. And then all of a sudden, all the headlines started, ringing, and Senators Leahy and Senator Grassley and others were wondering why one particular developer is getting more funds into their one project than several states combined. And I think that's when the disagreements came about. But it's really interesting. You have a senator, from Vermont and Iowa, the Republican, Democrat on one side of the debate, and then you have the more populous states being presented on the other side of the debate. But who are the people that are opposing this bill? Who are the people that are trying to kill this bill, and why? And can you maybe talk on that, or speculate on that if you would like?
I can try. I always want to be careful here as well. There is another association or coalition called the EB-5 EB-5 Investment or Investors Coalition. They're comprised of a small handful of companies and interests that represent the opposition and the reasons for opposition that I had mentioned earlier. Concerns that the integrity measures are overreaching in some instances, and concerns as well about what is not in the bill as opposed to what is in the bill. The bill doesn't address TEAs and investment amounts, for example. For the record, I believe the integrity measures are not overreaching. I believe the integrity measures were well thought out, debated and vetted thoroughly with the bigger industry representative, IIUSA, and we agreed to them with Grassley and Leahy as we developed the legislation. And I understand that the integrity measures are new and represent change in business models sometimes, but they're necessary for the longevity of the program, to tell you the truth. The other issues as to what is not in the bill, investment amounts, TEA definitions, et cetera, I will also say for the record that IIUSA is not opposed to addressing them. We never have been opposed to addressing them. We do believe that investment amounts need to be discussed. We do believe that there will always be room for discussion around the definition of TEA. We do believe that there needs to be a really fervent and sincere effort to address the backlog of applicants. We believe that we need to address processing times. We believe that we need to increase the number of visas. We believe that the derivative count needs to be formally addressed to allow more investor visas. It's not that IIUSA opposes these concepts or opposes the way that those issues and conversations can improve the program. What we've recognized from day one is that these conversations are contentious. They are typically drawn out. They are very detailed and sticky and politically sensitive, because you have those debates between rural and urban areas. And IIUSA represents everybody, across the country. And when Senator Grassley and Senator Leahy wisely decided that in order to reauthorize the program and provide the program longevity and stability in the marketplace by saying this program is not going to be year to year to year, it's going to be multiple years. But we're not going to address the contentious issues because they are not politically viable before this program expires. IIUSA recognized not that we shouldn't address those issues, but that we can't address them now in order to pass the bill that needs to be passed. Those discussions were just not politically viable. We need more time to get together and to truly vet and come up with a better game plan. And a lot of things have changed, over time as well. We have a new administration, for example. So the opposition to the bill is that overreach argument, what's not in the bill argument. I think IIUSA is in a smart position. We 100% support the integrity measures as written. We don't want to see them changed. And although we want to address things like investment amounts, we also understand that if you're going to try to do it now, you're going to throw the baby out with the bathwater. You're not going to get a program at all. So it begs the question: who among those in the EB-5 IC are opposing the bill for those reasons, and why? I can't say why anybody is opposing them. I can tell you that Senator Schumer, the majority leader, convened a very large meeting of stakeholders. Abdeen, you were there. I was there. We also had other members of the IIUSA board and other representatives from New York, because Senator Schumer from New York. So we had them there. And I believe just about everybody from the EB-5 IC was also on the call. And those individuals, interestingly, who have repeated the mantra that the program doesn't work for New York, they understand their audience is Mr. Schumer, none of them are from New York. It was very interesting to me to see that you had representatives in the coalition from, admittedly across the country, California, Florida, Maryland,
China.
There was an organization there that represents Chinese nationals. So China, which is a very interesting political conversation to have, I suppose. Nobody from New York. And I don't know if that was lost on everybody. It certainly wasn't lost on me. But it is an interesting coalition that has developed. They definitely have political capital to spend, and they've done so. I look forward to working with them down the road, assuming that we do have a program to improve further. And I think it's fair to say that there's a difference of opinion as to how we get there right now. And I think it's a shame that a small group of organizations is holding up progress for the entire program. My personal opinion.
Aaron, I agree with you. I think, whether it's IIUSA or IC, the Investment Coalition, I think we all want the same thing. We want the program to work. We want the program to, go back to its, days of glory, or, more than, 2019 or 2020, which means, softer investment amounts, easier way of processing, less wait times, and investors don't have to sit around and wait for 10 or 15 years to get their residency. I think we all want the same thing, but like you mentioned, the part that we disagree on is how do we get there? And that's, we all want the best for investors. We all want the best for the program. But, I want to ask a question for Priya, and I want Aaron to have you weigh in on it. I'm in New York, you're in Pennsylvania. Priya's in Dubai right now, where she lives, and that's where she operates. So she's on the forefront, that she gets to see investors on a daily basis. And, 3 or 4, when this program first started 30 years ago, there was only 1 or 2 countries that had investment migration programs. This podcast, it's called the Investment Migration Report. So we talked about not just EB5, but other programs. Today, there's more than 40 different programs from various different countries. And unfortunately, it's a zero-sum game. The billions of dollars that were coming here in the United States that were helping economic activity but more importantly, people were coming here and becoming residents and paying US taxes on their worldwide income. That money's not coming here anymore. And that money is going to various different countries. Like I said, 40 different countries. Priya, maybe you can weigh in on that. Where is this money going today? What are the various programs that it's going to? And I'd love to hear your point of view on it as well.
So there are obviously a lot of new programs that have cropped up in the past couple of years. I don't know, maybe countries and governments looking at the US and Canada as an example of how they've been able to improve their economies by using these types of immigration programs. But some of the ones that are really popular are obviously the EU countries, because, you know, when you look at the quality of life and the lifestyle, a lot of people look towards the West, like Canada and the US, for that security and for that quality of life. But, you know, second in line to that is the EU. So programs like Portugal, programs like Spain that offer the golden visas, they also have points to them that are positive points in people's eyes. For example, the Portugal program has a less stringent requirement on residency in order to get to the passport. The price is relatively the same. It's 500,000 euros to participate in the program, even less than that in some circumstances. And same with Spain. So those are other options that people are now looking towards, especially since the price of EB-5 has gone up to 900,000. Those just seem like more affordable options while still providing that security that immigrants are looking for.
And it's interesting, you know, I think the United States residency and also to become a naturalized citizen, which many other countries don't offer, I think it's the most valuable visa. It's the most valuable passport to have. And then you get access to 250 plus, you know, elite universities the United States has that no other country has, coupled with, you know, how easy it is to start a business and be an entrepreneur, which many investors, you know, many immigrants come to the United States and start businesses and become entrepreneurs. There really isn't any other countries that could offer what the EB-5 program offers. But the challenge is the long wait times. I mean, that's kind of the you know, why we're losing so much foreign investment dollars to other countries.
There's definitely two challenges. There's the long wait times. I mean, EB-5 has gotten so lengthy in terms of people waiting for some kind of status, waiting to make that move. That's number one. And number two, like I said, the price increase has just made it, unfortunately, not as affordable for some families, and they would rather opt for something else where they don't have to invest so much. So I think those are the two major barriers or issues when it comes to the EB-5 program if you're comparing them to some of the other EU countries, for example.
Aaron, your thoughts on that topic?
Well, this program was created as an economic development program. It's a successful economic development program for the United States. And I think it's worth understanding fully that it's not the only one in the world, that there are other programs out there who are successfully doing the same thing. And the extent to which the United States is attractive for investors really needs to be balanced with the realities that they face in coming to the United States. And, you know, a wise investor will take everything into consideration. And if there's a program in Portugal that offers 80% of what an investor wants, and they're able to reach those goals in 18 or 24 months, as opposed to coming to the United States where they may have 99% of what they want, but they risk not being able to enter the United States at all, even if they've made an appropriate investment, or at the very least, they may have to wait years before they're provided a visa. I don't know. There wise investors will take those things into consideration, and therefore, so too should U.S. Congress here in the U.S. if we are actually going to leverage the ability of the EB-5 program to execute economic development, which is why it began. I think you guys make a very good point.
Aaron, do you think regional centers and groups that are actively lobbying to try to stop these bills from passing, do you think they potentially face liability, maybe class action lawsuits from their existing investors that may lose their immigration benefits?
I have no idea. That is something I would be unwise to speculate on. I think there will be some angry and upset people, but I could never speak to liability or the possibility of class action lawsuits. Those conversations are always out there, but I certainly that's a question that's above my pay grade. I wouldn't be able to give you a good answer on that.
I'm hoping by the time our listeners get to listen to this program that everything's solved and we have a 5-year reauthorization, and we're working on improving the program to get additional visas and make it easier on TEAs and make the program work for everyone. But if that hasn't happened, we'd love to have the audience listen to this program and weigh in on the experts like Aaron that are in the forefront, talking to members of the House and Senate on a daily basis, and then people like Priya that are talking to investors on a daily basis to try to get investors to improve their lives and the lives of the children by immigrating to the U.S. or Canada and other countries.
Well, my hat's off to you guys. No matter what, when people listen to this podcast, I think they will have an opportunity to learn a lot. I think you guys have done a really good job at identifying some pretty important issues that will continue to be part of the EB-5 conversation long after tomorrow or the 30th. Guys, even if we do get our reauthorization, I don't know, I'll have a beer and take a nap, but there's a lot more work to be done after that. The conversation will definitely continue, and this podcast is a great way to start it off. So my hat's off to you guys for doing a great job in putting this together.
And thank you, Aaron, for being our first guest. It's been an honor, and it's been very informative. And Priya, any final thoughts?
Yeah, I think this is a really exciting time in EB5. There's so much going on. Thank you so much, Aaron, for your time today and for being our guest on the show. And we just look forward to seeing what's going to unfold, I guess.
Yes, ma'am. I do too. We will see. Today's going to be a very interesting day. It's 9:30 on the East Coast here, so things are just getting ginned up, and I'm seeing the emails start to come. So it's going to be an interesting day.
Well, thanks, Aaron. Thanks for being here, and we'll let you jump off to answering the hundreds of emails that you get this morning.
My pleasure, guys. Best of luck, and look forward to talking to you again soon.
Thank you.
So
Sorry. You too. Bye-bye.
Thank you for joining us on the Investment Migration Report with Priya Malik and Team Vaziri. We look forward to hosting you on our next episode.